What happens if your permanent residency application under the START visa class has been denied? Hi, my name is Ka from Sinka Immigration. We have helped successful businesses and individuals like yourself to move to Canada. And today, we'd like to let you know what are the follow-ups if your START visa has been refused. So if you experience a refusal or denial in your startup visa application, and you believe that there's certain errors in the decision-making process, this video is going to help you to determine what your next steps are. And surprisingly, immigration officers can make mistakes, and there are measures available to revive an application after refusal. A rejection does not necessarily mark the conclusion of your immigration journey. Now, upon receiving a refusal, it's crucial to thoroughly review the letter from the immigration department and acquire your global case management system notes to understand the specific grounds for the decision. Now, depending on the particulars of your case and the reasons for the refusals, you have many options to explore. These options include reapplication, requesting reconsideration, and trying to get into a strategy that is less well known, which is called judicial review. Now, first point, what is a judicial review in the Canadian immigration? Now, simply put, a judicial review serves as a reassessment of your application's rejection. It involves a legal procedure that a court examines whether the decision to deny your visa was just and compiled with the Canadian law. This process ensures that the denial of your application follows the legal criteria, and that protects your right by validating the fairness and legality of the decision-making process. Now, who is eligible to seek a judicial review for Canadian immigration? We only recommend certain applications to pursue this route. If your initial application lacked documents, was weak, or has significant gaps, then a judicial review is not the ideal option for you. As an immigration consultant, my goal is to craft thorough application that address all potential issues and furnish reviewing officers with well-documented evidence to support every claim made. So if your application was prepared in this manner and still encountered a refusal, you might be an appropriate candidate for judicial review. Now, seek legal counsels and representation from an immigration lawyer to ascertain the legal grounds for the review, such as errors in law, procedural failures, or breaches of natural justice principles. They can offer advice on the validity of your case and represent you in court. Now, familiarize yourself with the timelines and procedures for submitting a judicial review application. Note that there is a specified time frame for applying for judicial review after receiving the refusal notification. Additionally, it's important to understand the leave requirement before applying for judicial review. Now, under Canadian immigration law, if you disagree with a decision concerning immigration, such as a visa decision, you cannot directly challenge it in court. Initially, you must seek the court's permission to review your case, known as seeking leave. Essentially, you are requesting the court's approval to present your argument at a hearing. This requirement now extends to visa decisions as well, which previously did not require this step. Consequently, the process consists of two stages. First, you submit your request in writing. The court evaluates it and determines if your case merits further consideration. If the court denies your request, your challenge ends there, and this decision cannot be appealed. However, if the court grants your request, you proceed to the second stage where you present your case at a hearing. This entire process was referred to as applying for leave and judicial review. What would be the most effective approach for initiating a judicial review in Canadian immigration cases? Now, understanding and clearly presenting grounds for judicial review is essential. These grounds may include demonstrating errors in law, incorrect factual determinations, breaches of natural justice principles, exceeding of authority, or any other legal deficiencies as stipulated in the Federal Courts Act. Making compelling agreements supported by thorough documentation is crucial for convincing the court of the necessity for a review. Moreover, similar to any legal process, following the procedures, timely and accurate communication, thorough preparation of case materials, comprehension of the legal rationale for review, and strict following to court orders and timelines are vital for achieving a successful judicial review process. Now, shall one consider reapplying following an unfavorable decision on a judicial review for Canadian immigration? Now, if the leave for judicial review is granted, but the judicial review itself is subsequently denied, the tribunal's decision is upheld, indicating that the court deems the decision-making process lawful. Consequently, the original decision made by the Immigration Department officer remains valid and enforceable. In such a scenario, reapplying may not be the most practical or strategic approach. However, it's worth noting that if the judicial review process results in the decision being overturned and the matter is remitted for redetermination, the immigration officer's initial decision is effectively invalidated. This nullification allows the parties involved to proceed as if the original decision had never been made, giving a different officer the opportunity to start anew. This fresh determination can consider any new facts that have emerged since the original decision. The officer or panel conducting the redetermination must follow the principles of procedural fairness and comply with any specific directions or conclusions determined by the court during the judicial review process. Now, what responsibilities does a Canadian immigration consultant fulfill? Now, an immigration consultant are unable to offer legal counsel during judicial proceedings. However, they play a vital role in preparing initial applications to ensure compliance with all the standards, thereby establishing a strong foundation shall a judicial review become necessary. Now, in summary, effective navigating a judicial review for a startup visa demands a well-crafted strategy and comprehension of the legal framework. By securing expert legal representation, following procedural deadlines, and developing a compelling case that addresses errors in the visa decision process, applicants can effectively contest unjust visa denials. The judicial review process underscores the significance of a prepared initial application, serving as the cornerstone for any potential legal challenge. This highlights the importance of ensuring applications meet all required standards. Now, approaching a judicial review with pragmatic expectations and a thorough understanding of its procedural intricacies, particularly the two-stage process of seeking leave and then, if granted, proceeding to the review itself is imperative. So although not every application may be suitable for judicial review, for those that are, it presents a pivotal opportunity to overturn wrongful decisions. This avenue offers optimism for individuals confronted with the daunting prospect of a visa refusal. Are you interested in learning more about refusals? At Sinca Immigration, we have helped lots of businesses and individuals who have experienced refusals. And if you're interested, please subscribe to our channel. My name is Ka from Sinca Immigration. Thank you for listening, and we look forward to seeing you again soon.